Welcome to Employment Law This Week. I'm George Whipple. NLRB General Counsel Jennifer Abruzzo joins the fight against non-compete agreements. In a May 31st memo to regional directors, Abruzzo stated her position that non-compete agreements for employees protected by the National Labor Relations Act violate federal labor law except in limited circumstances. So what does this mean for employers? Epstein, Becker, Green's Spilling Secrets team digs into this question this week in the latest episode of their podcast series about trade secrets and non-compete law. Epstein, Becker, Green's Pete Steinmeyer tells us more about the GC's memo.
The memo, while not law, outlines her legal theory that she will present to the National Labor Relations Board. The memo provides guidance to the agency's field offices of the position that the General Counsel is instructing them to take when investigating unfair labor practice charges, claiming that such clauses interfere with employees' rights under the NLRA. So this is yet one more forum in which traditional non-compete agreements are under attack.
Epstein, Becker, Green's Erin Schaefer draws on her experience as a field attorney for the NLRB to point out the possible future implications of this memo.
And so if you're reading it so broadly, you can pour a whole lot of employment practices and restrictions on employees' abilities into that bucket that the statute is creating. And so that's really what this memo outlines, which is a series of hypothetical scenarios that would be protected concerted activity that would also be restricted by these non-competes.
Epstein, Becker, Green's Steve Swirsky was also a field attorney for the NLRB at the beginning of his career. He points out that when GC Abruzzo instructs the regional directors to take a particular position as they investigate charges against non-competes,
she also is really telling them when they get cases with those issues before them that she wants them to issue complaints so that the question of whether these clauses unlawfully interfere with employees' Section 7 rights under the National Labor Relations Act can be brought to trials before the agency's administrative law judges and ultimately brought before the 5-member board in Washington for the board, in her view, to hopefully adopt her interpretation of the act and to expand this coverage.
The real repercussions of the memo will only be felt in time. Epstein, Becker, Green's Erik Weibust speaks about how it will affect the way he advises clients.
I'm not going to say just because the NLRB's general counsel came up with this rule that employers should not use non-competes with non-supervisory employees. It's just part of the discussion. You've got, of course, the FTC, but you've also got different state laws. It's up to the client, with my recommendation and my advice, to make determinations as to what their risk tolerance is.
Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.